May I confirm the presence of our witnesses? I see Officer Wentz. Okay, I see Detective Booth. Great. May I ask if the two experts are present? Do we know? All right, let me ask the prosecution. Is your expert present? You can check the participants bar and let me know the name.
I don't see him, Your Honor. I am contacting him presently to make sure he hops in here as soon as we can get him in here.
Thank you, Mr. Van Zandt. How about from the defense expert?
Your Honor, the expert was in the Zoom room. However, I will contact him to see where he went.
Okay, as soon as you folks hear back, let me know. I'm going to sit tight till our experts appear. Courtroom 7 is missing both experts, but the respective teams are contacting them now.
Your Honor.
Yes.
The defense's expert had a Wi-Fi issue, but he stated that he is currently waiting to be let back in.
Hi, is that Jay Kadiwala?
Correct, Your Honor.
Okay, your expert has been admitted.
Your Honor, I've established contact with our expert. He says that he is hopping on at the moment.
Super. We'll sit tight and await that. I am sorry to report this, but the expert seems to have disappeared from our participant list. The expert whose first name was Jay.
Oh, Your Honor, Jay changed his name to the expert that is listed in the problem.
Well, I just admitted Dr. Riley. Doctor, good morning.
Good morning.
Do we have a Dr. LaGreca?
We should, Your Honor. He said the password just took. He should be in here momentarily. My
Super,
apologies
super.
for the continued delay.
All right.
Yeah, I believe there they are.
Oh, there he is.
And they're in magically. All right. I now need to get approval, if you will, to start our proceeding. So let me do that, friends. I'm sorry, friends. I apologize for the delay. Please relax. I just have to get the clearance. All right. Friends, good morning.
Good morning, Your Honor.
Thank you. And Mr. Van Zandt, you're good. All right. I am now formally convening court. Everyone is here and we have just received the message to get started. I call the case of State of West Carolina versus Timothy Ray. My name is Judge Epstein. Scoring judges, please look at the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until the trial ends. You should also have your video set to, quote, hide all non-video participants. That means the only people on the screen right now should be the four advocates and me, and that appears to be the case. Counsel, will you please enter your appearances? Let me start with prosecution.
Yes, Your Honor. My name is Alex Van Zandt, and along with my co-counsel, Eric Honey, I will be representing the state of West Carolina.
And forgive me, so I say it right, is it pronounced Honey?
Yes, Your Honor.
Mr. Honey, thank you, kind sir. All right. And for the defense, please.
Good morning, Your Honor. My name is Joseph Fay, and I, alongside my co-counsel,
Benjamin Usha.
represent the defendant, Timothy Ray, in today's matter.
Okay. Welcome to you all. Counsel, is there anything preliminary that I need to address, or may we begin with opening statements?
Your Honor,
Issues.
All right. I'm glad both of you were ready. I'm going to just go in ordinary order, so I will start with the prosecution.
if I may, Your Honor,
You may.
the defense has three motions limine we would like to address.
All right, but I'm going to go, because the prosecution has the burden, I'm going to start with them, but I've got it and I will hear your motions. Mr. Van Zandt, it looks like you were ready to start. Counsel,
sir.
proceed.
The prosecution wants to know if we are supposed to formally tender witnesses before Your Honor, because we are operating off the federal rules of evidence.
And when you say tender, are you referring to the experts or in
Yes.
general?
Just the expert witnesses. Your
Yes,
Honor.
we will. You will make an offer and we'll see if the other side objects.
Yes, sir. One more matter, just as a point of clarification, my co-counsel Eric Honey will be referring to a PowerPoint presentation during the trial. And I just wanted to preliminarily throw that out
Has
there.
that been shared with opposing counsel? Are there any objections or problems with this?
That has not been shared with opposing counsel, Your Honor.
Was there any pretrial communication between the sides?
Opposing counsel did not reach out to the defense concerning communications, Your Honor.
How about did defense reach out to the other side?
No, we didn't, Your
Your
Honor.
Honor, we actually tried to contact them, and the team that they were matched up before also said that they did not reach out for any pretrial matters.
Okay, how big, Mr. Honey, how many slides are in this PowerPoint?
It is, I believe it's only 4 exhibits, Your Honor.
So why don't you, are they altered or are they just the exhibits?
They are only the exhibits. There's been no alterations, no demonstrative exhibits.
Right, so why don't you just tell us the number of those exhibits, if you would be so kind? You muted, Mr. Honey, my apologies.
Yes, Your Honor. Exhibits 29, 19, Exhibit 4, and Exhibit 10.
All right, Mr. Fay, since you were responding here, any problem with any of those, or can we just have an objection if there is at time of introduction?
Only to exhibit 19.
Only to exhibit 19. Mr. Honey, kindly remind me which is exhibit 19?
Your Honor, Exhibit 19 is a picture of the victim, Nathan Ray, as he was found in the park.
So that's one of the trash bag pictures, if you'll forgive me.
Yes, Your Honor. And I apologize. I also had only one other, and that was Exhibit 27, the picture of the belt in the. in
The belt in the room.
Yes, Your Honor.
So, Mr. Fay, what I'm going, do you intend to try and show any of these in your opening?
No,
We
Your Honor.
do-
Fine, then gentlemen, we will address these as they come up in the trial. Okay. Mr. Van Zandt was added on what sometimes are called housekeeping matters.
Yes, Your Honor, the housekeeping matters have all been taken care of. I'm the same.
Does the prosecution have any motions such as motions in limine?
No, Your Honor.
Very good. Mr. Fay, the floor is yours. You explained you have 3 motions. The court will hear them.
Yes, Your Honor, but before we get into motions to eliminate, may the defense address a few housekeeping matters?
You know what? Let's go to the motions and we'll do that at the end. Thank you, sir.
Your Honor, at this time, the defense has 3 motions in limine. Concerning the first motion in limine, the defense moves to exclude any and all evidence provided by the prosecution's witness, Dr. LaGreca, that focuses on the ultimate issue in this case, determining whether the defendant, Timothy Ray, knew right from wrong. May I be heard?
Well, let me just ask Mr. Who's responding? Mr. Van Zandt or Mr. Honey? Mr. Van Zandt, what's your position on that?
Dr. LaGreca will not be testifying to the ultimate issue. This is an unnecessary motion, Your Honor.
Got it. You've won your first motion, Mr. Fay. Next motion, please.
Your Honor, the second motion in limine pertains to exhibits 18 through 21, which for the court's clarification are the photographs of Nathan Ray in the trash bags. The defense requests that these exhibits be barred.
On what grounds, please?
Yes, Your Honor. Pursuant to Federal Rules of Evidence 403, these photographs are not only unnecessarily and needlessly cumulative, but the probative value of such photographs are substantially outweighed by the danger of unfair prejudice to the jury, basing guilt off of the photographs alone.
Mr. Van Zandt, I understand Mr. Honey wants to use at least one of those. What is the government's response in terms of cumulative and unfair prejudice?
Your Honor, first and foremost on unfair prejudice, this evidence is actually far more probative than prejudicial because it gives direct insight into the process of the investigation itself, which is going to be a point of contention during trial. As far as the cumulative argument goes, this evidence hasn't been compiled, right? We're probably only going to enter one of these photos. If we try to enter all of these photos, then at that time, defense counsel can make the argument that this evidence is cumulative and is a waste of the jury's time.
Would you just elaborate for one moment on what you mean about the integrity or whatever it is of the investigation?
No, it was it gives us a little bit of insight about the investigative process, just the process.
About the investigative process.
Yes, sir.
Mr. Fay, your response briefly.
We stand by our prior argument. So long as opposing counsel does not enter every single photograph, then that is not cumulative, and we still stand by our argument concerning the probative value being substantially outweighed by the danger of unfair prejudice.
My ruling is, especially since it is not going to be referred to in the opening or shown in the opening, I am not going to rule now. When you get to the point where you wish to use that, simply say, Your Honor, may we see the court at sidebar. I need a little context to understand how that would fit into the investigative process. Mr. Fay, your last motion, please.
Yes, Your Honor. Pursuant to Federal Rules of Evidence 615, the defense now moves to constructively sequester all non-party and non-expert witnesses during the proceedings.
Any objection, Mr. Van Zandt?
Not this time, Your Honor.
Great. Okay, sequestration is ordered. I take it that's to the 2 law enforcement witnesses. Mr. Fay, you said that you also had some housekeeping matters. Please tell me what they are.
Yes, Your Honor. May we presume that all of the witnesses are constructively sworn?
Yes.
And may we presume that all objections are heard outside of the presence of the jury?
No. You would have to request a sidebar if you feel it appropriate for that particular objection.
Okay, Your Honor, that is all the housekeeping matters and motion to eliminate from defense.
Okay, fine. Having completed the pretrial matters, we will now hear opening statements from each party. Everyone should make sure they are in speaker view. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking and just before I hear from the prosecutor. I will remind each side that you have a timekeeper or timekeepers. I will ask them to unmute at the end of the prosecution case and again at the end of the defense case to see where we are. With that, we will proceed. Prosecution, it is your opening statement.
May it please the court. I won't let them leave me. I just won't. These are Timothy Ray's own words, not voices in his head. These are Timothy's own thoughts, which he spoke into existence before he killed his son, Nathan Ray. Conscious, controlling, cold-blooded. I am Eric Honey, and I, along with my co-counsel, Alex Van Zant, are here to represent the state in proving the defendant, Timothy Ray, was conscious, controlling, and cold-blooded when he murdered his 6-year-old son, Nathan. On October 17th, the defendant wrapped a belt around Nathan's little neck and choked the life from him. How do we know this? Because Timothy confessed it. He confessed the murder to police. He confessed it to Detective Blake Booth. And he confessed the murder to the defense's own expert, Dr. Riley. In the months leading up to Nathan's murder, Timothy's wife, Jessica, had separated from him. And just a couple of days before Nathan was killed, Jessica told Timothy that she was filing for divorce. Timothy Ray had already declared that he would not let Jessica or Nathan leave him. And on the morning of October 17, 2018, Timothy Ray followed through with this promise. You will hear testimony that when little Nathan spilled his apple juice on Timothy's laptop, Timothy had to punish Nathan. And he punished Nathan by making him do jumping jacks and running in place and doing high knees. Then when Nathan stopped doing these exercises and yelled for his mom and told his dad that he hated him, that's when Timothy killed Nathan. Timothy consciously went to his own bedroom, sat on his bed for a few seconds, then got a belt and went back to Nathan's room. Timothy took that belt and he wrapped it around Nathan's neck and he pulled it tight. Timothy told police, I pulled the belt until he stopped screaming. Until he stopped moving. We, the state, have the burden to prove that Timothy Ray committed first-degree murder when he killed Nathan Ray. We must prove that Timothy Ray willfully killed Nathan. Our burden is to prove that Timothy Ray is guilty beyond a reasonable doubt. Now, beyond a reasonable doubt is not proof beyond all doubt. So what is reasonable doubt? Reasonable doubt, as you will be instructed, is the type of doubt that would cause a reasonable person to pause or hesitate when making a decision of importance in his or her own life. Ours is a heavy burden, and we welcome our burden. Timothy has chosen to assert that he is not guilty by reason of insanity. In choosing this defense, the burden shifts to Timothy to prove, one, that he suffered from a severe mental disease or defect at the time of Nathan's murder, and two, that as a result of a severe mental disease or defect, that Timothy was unable to appreciate the nature or quality of his acts, or that he was unable to appreciate the wrongfulness of his act. And Timothy must meet that burden by clear and convincing evidence. In other words, that it is highly and substantially more likely to be true than not true. So what will you hear and see during this trial? Well, the evidence will show that after killing Nathan, Timothy never once called for medical assistance. Timothy never once called for the police. But what Timothy did do was Google search countries that don't extradite from murder charges. What Timothy did do was Google search how to get rid of a body. What Timothy did do was Google search how bleach destroys a body. You will hear evidence that during the investigation, police detective Blake Booth conducted search warrants on Timothy Ray's car and house. And in Timothy Ray's car, he located bleach, trash bags, and a shovel. And from the house, a belt on the floor of Nathan's bedroom. You will hear about Timothy's confession to Detective Booth, about how he strangled Nathan with a belt in Nathan's room, and how afterwards he put Nathan's body in a trash bag and he buried him in a park in a shallow grave. You will also hear from experts during the trial. You will hear how 3 different doctors, one of which is the defendant's own expert, Dr. Riley, who happened to have examined Timothy in 2010, all documented that prior to Timothy's arrest, he never once reported having hallucinations. He never reported hearing voices, and he was only ever diagnosed with having anxiety and depression. You will hear evidence about Timothy Ray's visits with his own personal physician, Dr. Giuseppe, in 2014, when he explains that Jessica threatened to leave him. And that is when he first said, "I won't let them leave me. I just won't." You will hear the state's expert, Dr. LaGreca, testify that Timothy Ray did not suffer from any schizophrenia or any other severe mental disease. The expert will testify that there is no evidence that Timothy's anxiety progressed over time to any severe mental illness. Ultimately, at the close of evidence, you will have heard how Timothy Ray needed to be in control. And when he was losing that control, Timothy Ray consciously made the decision to follow through with his own words from years before. "I will not let them leave me. I just won't." You have the power. You have the power to bring justice to Nathan. Timothy's wife left him. She was divorcing him. And Timothy hated him and wanted to be with his mom. But Timothy could not let that be. So he took that control away from them. At the close of this trial, we pray that you take back that control that Timothy took from Nathan and Jessica and find the defendant, Timothy Ray, guilty of first-degree murder in the killing of his son, Nathan. Thank you.
Okay, thank you, sir. Defense, do you wish to give your opening now or reserve it till later in the trial?
We wish to give it now, Your Honor.
All right. Mr. Yusha, the floor is yours, sir.
The only way to explain this insanity is with insanity itself. Let's get 2 things perfectly clear. First, no one is disputing that what happened to Nathan Ray was an absolute tragedy. No one's life, especially a 6-year-old's life, should ever be cut short. And second, no one is disputing that Mr. Ray was the cause of his own son's death. But that brings us to why we're here today. That one word, why? Why would Mr. Ray do something as insane as kill his own son? The only way to explain this insanity is with insanity itself. Members of the jury, you will hear today that insanity is a legal term, but the medical term that describes what Mr. Ray is actually suffering from is schizophrenia, a psychotic disease characterized by hallucinations and delusions, severely interfering with a person's perception of reality. You will hear from 2 psychiatrists today who agree on what causes schizophrenia. First, you will hear that both experts agree childhood trauma can cause schizophrenia. And the evidence will show that Mr. Ray's childhood was, in fact, traumatic, full of abuse from his mother and neglect from the rest of his family. His mother was institutionalized at a very young age, and he never saw her again. With no one around, Mr. Ray began hearing voices in his head that crippled him with fear. You will also hear both experts agree that an untreated mental illness, like anxiety, can cause schizophrenia. And that's exactly what happened with Mr. Ray. In his early 20s, when Mr. Ray was serving our country in the military, he was diagnosed with generalized anxiety disorder. This is not the same anxiety that we feel from time to time. This is a debilitating anxiety, persistent throughout all moments in life. For 8 years, Timothy hung on to this anxiety, and he received no mental health treatment for it. Finally, we will hear how all of this culminated into Mr. Ray's schizophrenia, and how and why that schizophrenia played a direct role in Nathan's death. We will hear how Mr. Ray had the delusion that his wife and his son were conspiring against him. They wanted to sabotage his job. They wanted to cut him up into little pieces and to leave him forever. And we will also hear how Mr. Ray had the hallucinations in the form of the voices in his head, the same ones he heard in childhood, telling him to punish and kill Nathan Ray. Members of the jury, it is our burden to you today to prove that 1, Mr. Ray had schizophrenia, and 2, because of that schizophrenia, he could not appreciate the wrongfulness of his actions. Our burden is different from the prosecution's. Their burden is beyond a reasonable doubt, the highest standard in our legal system. Our burden is by clear and convincing evidence. That is a burden we will meet. Mental health is not something you can just sweep under the rug. It's not something to tell someone that they're lying about or making up. Mental health disorders are real and affect the most powerful organ in our body, our mind. Mr. Ray is one of the people who's affected by a mental health disorder. And on October 17th, 2018, Mr. Ray's schizophrenia took the wheel of his life out of his hand and drove him to do something no sane person would do. For these reasons, we ask that you find Mr. Ray not guilty by reason of insanity.
Thank you, counsel. Forgive me 1 second. Before the state calls its first witness, I am asking everyone to please switch to gallery view. It's up in the top right-hand corner. Everyone should make sure they are in that view. This will allow you to see the attorneys and witness at the same time. Prosecution, please call your first witness.
Your Honor, the prosecution calls Detective Blake Booth.
Detective Booth, good morning. You have been sworn. Please keep your voice loud and clear. Mr. Honey, you may proceed.
Thank you, Your Honor. Detective Booth, will you please tell the jury your name?
My name is Blake Booth.
And what is your profession?
I'm a detective with the Skelton Police Department, currently assigned to the homicide unit.
Did you become involved in a homicide investigation regarding Nathan Ray?
Yes, I did.
Did it stem from any other investigation?
Yes, it followed a missing persons report about Nathan Ray.
Detective Booth, who filed that missing person report?
Nathan's mother, Jessica Ray.
And when was that missing person report filed?
October 18th, 2018.
And what were the details of this report?
Jessica Ray, his mother, was supposed to pick Nathan up from his father's house, Timothy Ray, but she was unable to locate either of them.
Who's Nathan's father?
Timothy Ray.
What else did Jessica do to locate Nathan?
She went to his school, but he had not been seen there since the 16th.
Detective Booth, was there a suspect listed in this report?
Yes, Timothy Ray.
And did you receive anything to help you identify Nathan?
Yes, I had a picture of him.
Will you please turn to Exhibit 29 in your notebook?
Just one moment. There.
Detective Booth, will you tell the jury what Exhibit 29 is a picture of?
It's a picture of Nathan Ray at 6 years old.
Is this a true and accurate depiction of that photo?
Yes, it is.
Your Honor, the state offers Exhibit 29 into evidence.
Mr. Osha, any objection?
No objections, Your Honor.
It is admitted.
Thank you, Your Honor. Permission to publish to the jury.
Yes, and gentlemen, going forward, once it is admitted, unless the other side explicitly objects to it being displayed to the jury, you have automatic permission to display.
Thank you, Your Honor. Detective Booth, is this the picture that you received of Nathan Ray?
Yes, it is.
And did you ever locate Nathan?
Yes, his body was found in Brandywine State Park.
Did you go to the park?
Yes, I did.
Will you please turn to Exhibit 19?
I'm there.
What is this a picture of?
This is a photo of Nathan as he was found in the park.
Is this a true and accurate depiction of the photo?
Yes, it is.
Your Honor, the state offers Exhibit 19 into evidence.
Mr. Usha,
Your Honor, we object pursuant to Rule 403. The probative value of this photo is substantially outweighed by the potential for unfair prejudice by inflaming the passion of the juries.
my recollection, gentlemen, let us approach it sidebar. My recollection is this is the issue that was discussed in pretrial rulings that I held under advisement.
That's correct.
Okay, given the context in which it has been presented, I will permit the use of the photo. The objection is overruled. We're now back in front of the jury.
Thank you, Your Honor. Permission to publish to the jury, Your Honor.
As stated, yes.
Thank you. Detective Booth, please tell the jury what they're seeing in these photos.
Well, this is a picture of Nathan when he was missing, and on the other side is a picture of Nathan inside a trash bag buried in a shallow grave.
And how did this investigation change upon finding Nathan's body?
Well, it was now a homicide investigation.
And who is the suspect in the homicide investigation?
Timothy Ray.
Let's move forward now, Detective Booth. Will you please tell the jury what happened on the night of October 19th, 2018?
I was notified and responded to a checkpoint where Mr. Ray was being detained off of Route 22. He
Where was the defendant when you arrived?
was handcuffed and sitting on the curb.
And where was the defendant's car?
He was pulled off to the side of the road.
What did you do with the defendant's car?
I looked through the windows with my flashlight, and I saw shovels and bleach and black trash bags in the back seat.
And what did you do with these items?
I'm sorry, you cut out. Could I get that question again?
Yes, Detective Booth, what did you do with the items that you found in the back seat?
Well, I cataloged them and made note to get a search warrant for later.
And what did you do with the defendant?
Well, I had the officers that detained him transport him from where he was being detained to the police station for questioning.
Let's talk about that interview. Detective Booth, did you advise the defendant of his Miranda rights?
Yes, I did.
And how did you advise him of his rights?
I read Mr. Ray's Miranda warning and waiver, and then I gave him the form to read, initial, and sign himself.
Detective Booth, please turn to Exhibit 4.
One moment. All right, I'm there.
Detective Booth, what is this a document of?
It is the Miranda warning and waiver that I gave to Mr. Ray.
Is it a true and accurate depiction of that Miranda warning and waiver?
Yes, it is.
Your Honor, the state moves to admit Exhibit 4 into evidence.
Any objection?
No objections, Your Honor.
It is admitted.
Your Honor, permission to publish to the jury.
Yes, permission to publish.
Detective Booth, please tell the jury what they're seeing in this picture.
They're seeing the Miranda warning and the waiver that I read and gave to Mr. Ray to read and sign.
And what does line number 1 read?
You have the right to remain silent.
And how did the defendant acknowledge that right?
He initialed that he understood.
What about line 2?
Anything you say can and will be used against you in a court of law.
And did he acknowledge this right?
He initialed that he understood.
What does line number 3 read?
You have the right to talk to a lawyer and have him or her present with you while you are being questioned.
And how did Timothy Ray acknowledge that right?
He initialed that he understood.
What does line 4 read?
If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish.
And how did the defendant respond?
He initialed that he understood.
What is on line 5 of that form?
You can decide at any time to exercise these rights and not answer any questions or make any statements.
And how did Timothy Ray respond to that?
He initialed that he understood.
Detective Booth, will you please read the paragraph under waiver of rights for the jury?
Yes, waiver of rights. I have read this statement of my rights and I understand what my rights are. I'm willing to make a statement and answer questions. I do not want a lawyer at this time. I understand and know what I am doing. No promises or threats have been made to me, and no pressure or coercion of any kind has been used against me.
Detective Booth, how did the defendant respond to this paragraph?
Mr. Ray signed his name and that he understood the statement.
Let's talk about the confession. What did the defendant tell you occurred on the morning of October 17th?
He and his son Nathan were at his house. He had fixed Nathan a bowl of cereal and some juice. While Mr. Ray was getting ready for work, Nathan spilled this juice on his work laptop.
And what did the defendant do when Nathan spilled his juice?
Well, he started yelling at Nathan, and then Nathan began crying, ran to his room.
What did the defendant do when Nathan ran to his bedroom?
He followed Nathan into the bedroom, and he made him do exercises as punishment.
What kind of exercises did he have him do?
Running in place, jumping jacks, high knees.
What happened then after the defendant made Nathan do these exercises?
Nathan stopped doing the exercises, but kept crying and screaming. At this point, Mr. Ray went to his bedroom and he got a belt from his closet.
What did the defendant do with the belt?
He went back to Nathan's room and hit Nathan on his bottom with the belt.
Detective Booth, please turn to Exhibit 6 in your notebook.
All right, I'm there.
Do you recognize this document?
Yes, this is Nathan Ray's autopsy report.
And did you review that report?
Yes.
Detective Booth, what did the autopsy report tell you about Nathan's death?
Said the manner of Nathan's death was asphyxiation and the cause of death was homicide.
And what did you learn about the external examination of Nathan's body from this report?
Nathan had injuries on his neck consistent with being strangled by a belt.
Detective Booth, can you turn to Exhibit 27 in the notebook?
Just one moment. All right, I see it.
What is this a picture of?
This is a picture of the belt that was found on Nathan's bedroom floor.
Detective Booth, is this a true and accurate depiction of the photo?
Yeah, it is.
Your Honor, the state offers Exhibit 27 into evidence.
Any objection, Mr. Russia?
No objections, Your Honor.
Admitted.
Your Honor, permission to publish to the jury.
Yes, permission has been granted.
Thank you. Detective Booth, what did Nathan do when he was hit with this belt?
He began to scream and he told Mr. Ray that he hated him and that he wanted to go to his mom.
What did Mr. Ray do?
Objection hearsay as to what Nathan Ray said.
All right, Mr. Honey, your response, please.
Your Honor, what Nathan said is not being offered for the truth of the matter asserted. Rather, it's being offered to show the effect on the listener that the defendant was inflamed by the comment.
Mr. Russia, a response?
I stand by my objection.
Very good. Objection respectfully is overruled. Proceed.
Thank you, Your Honor. Detective, I'll ask that again. What did Mr. Ray do when Nathan said he hated him?
Well, he put the belt around Nathan's neck.
What did Mr. Ray do after he put the belt around Nathan's neck?
He pulled the belt. He said he pulled the belt until Nathan stopped screaming, until he stopped moving.
Detective Booth, based on your training and experience as a homicide detective, how did Timothy Ray's confession match up to the autopsy report of Nathan Ray?
The autopsy report was consistent with Mr. Ray's confession about strangling Nathan.
What did the defendant do after he strangled Nathan?
He put Nathan in a trash bag.
And after he put Nathan in a trash bag, what did he do next?
He drove around with Nathan in his car for a few days.
And after driving around for a few days, what did he do?
He buried Nathan in the park off of Route 22.
Did the defendant say anything else before you ended your interview?
Said, "You have to help me, Blake."
And based on all your personal observations that you had with the defendant, what did you think that defendant meant?
That Mr. Ray knew exactly
Objection
what
to
he'd done.
speculation as to what the defendant meant.
Mr. Honey?
Your Honor, this is not speculation because it is Detective Booth's own impressions based on his observations of the defendant at that moment.
I'm sustaining the objection. I'm taking you both to sidebar for a different reason. It's not clear to me, gentlemen, A, whether what the detective thought is helpful to the jury. And B, we are encroaching on the problem of no comments on the defendant's intent. We're back in front of the jury. Mr. Honey, that objection is sustained.
Very well, Your Honor. Thank you. Let's briefly talk about the defendant's cell phone, Detective Booth. Did you ever conduct a search of the phone?
Yes, we did.
What kind of information did you get from the phone?
Some Google searches that were relevant to the investigation.
Detective Booth, will you please turn to Exhibit 10?
Just one moment. All right, I've got it.
What is this a picture of?
It is a screenshot of Mr. Ray's phone showing the Google search history.
And is it a true and accurate depiction of that screenshot?
Yes, it is.
Your Honor, State offers Exhibit 10 into evidence.
Any objection, counsel?
Objection to foundation. We have no idea whether Timothy Ray actually searched this on his phone. And we don't know where the investigator found this phone. So that's our objection.
Let's do one follow-up question. Would you kindly ask where the phone was found, Mr. Honey?
Your Honor, we don't know exactly where it was found. However, Stipulation 9 stated that it was Timothy Ray's phone and that had been accepted.
Based on that, the objection as to foundation is overruled.
Thank you, Your Honor. Detective Booth, what is this a picture of?
Did you plan to have this up at this point, counselor, or based on what I'm reading in front of me?
Oh, I apologize. Your Honor, the state asked permission to publish to the jury.
You may.
Detective Booth, what is the first search listed on the screenshot?
Countries that don't extradite for murder charges.
And what is the second search?
How to get rid of a body.
And the third search?
Will bleach destroy a body?
Detective Booth, what did you find in the back of the defendant's car following the car stop?
A shovel, trash bags, and 2 bottles of bleach.
Detective Booth, what is the date these searches were made?
October 18th.
And what significance does October 18th have, if any?
October 18th is the day after Mr. Ray says he killed Nathan, and the day before he was stopped and arrested.
Your Honor, the state passes the witness.
Thank you. Mr. Usher, cross-examine, please.
I'd like to turn your attention to Exhibit 4, which has already been entered into evidence. The time at the top says 1:56 a.m. Is that right?
Would you mind if I pulled this up in front of me real fast? The
Go ahead.
screen is that small. I have it up in front of me, Counselor.
Yes. The time at the top says 1:56 a.m., right?
Yes, it does.
That's the time you entered when the Miranda rights form was just being given.
Just given, that is the time listed for him signing it, yes.
And at the bottom of the form, it says 2:08 a.m. is when Timothy Ray signed the form. Is that correct?
That is the timestamp at the bottom.
So it took 12 minutes for Mr. Ray to sign this form. Is that correct?
I think your math is correct, yes.
Now, this is a simple form.
Yes.
You agree with me? It shouldn't take longer than a couple minutes.
I don't necessarily agree with that characterization.
But the interview with him was strange.
Nothing about it was odd to me.
He asked you if you're a CIA agent during this time, right?
I believe so at one point, yes.
You had to remind Mr. Ray that you're not in the CIA.
Yes, and that I was with the Skelton Police Department.
You had to remind that your name is Blake Booth.
Yes, I did.
You had to remind Mr. Ray that you're a police officer.
Yes, I just stated that.
And that this wasn't the only time Mr. Ray asked you whether you're a CIA agent.
At what point was not the only time, Counselor?
He asked you twice during the Miranda rights form and during the interview.
Yes, he did.
So for a second time, you had to remind him that you're not a CIA.
Correct.
And for a second time, you had to remind him your name is Blake Booth.
Don't know if I had to remind him of my name twice, but the CIA thing, yes.
And in fact, the second time, you had to remind him that you two know each other.
I don't know if I had to remind him, but I did remind him.
That your kids play soccer together.
Yes, they did play soccer together.
Now, the CIA wasn't the only strange thing Mr. Ray said during your interview.
Again, this interview was not odd to me.
Officer Booth, when you spoke with Mr. Ray, he said there were other people telling him to punish his son.
I can't speak to that statement, Counselor. I'm sorry. He was talking to me and everything he said seemed clear to me.
Well, Mr. Ray said, they made me do it.
Counselor, you were speaking a little softly. Could you a little louder?
Sure. Mr. Ray himself said, they made me do it. Is that correct?
I would have to check for the exact language, but something along those lines was said, yes.
So he said that, yes?
Yes, something along those lines.
And that he would have never done it had they not told him.
Yes, I believe that was part of roughly the same part of the interview.
That they told me to make him understand. That's what he said to you.
At one point in the interview, yes.
Now, you did not find evidence of anyone else in the house that day. on October 17th?
In Mr. Ray's house? No.
Because you would agree with me that the only people in the house on October 17th was Mr. Ray and his son, Nathan.
Yes.
Officer Booth, the other people Mr. Ray talked about, they were not real.
Again, I can't speak to these other people that Mr. Ray was speaking about.
Now, Mr. Ray, he said some other odd things during the interview. Is that correct?
For the third time, this interview was not odd to me.
Now, Mr. Ray believed that his ex-wife, Jess, and his son were conspiring against him.
Objection.
Counsel basis?
How the detective can't testify to what other people thought.
I think the question was that, did Mr. Ray say that? But unless that's it, your objection will be sustained. Mr. Russia, are these words that you're saying Mr. Ray said during the interview?
These are words that Mr. Ray himself said during the interview.
Got it. The objection is overruled. Detective, did Mr. Ray say those words or words to that effect?
I'd have to hear the quote again, but it was something along those lines, Your Honor.
Mr. Ray thought that Jessica tricked Nathan into spilling juice on his laptop.
Yeah, I do remember him saying something along the lines of she tricked him.
Mr. Ray said that Jessica wanted to take Nathan away from him.
Can't say for certain. That was the exact quote, but yes, again, something along those lines was said by Mr. Ray.
And to make Mr. Ray lose his job. That was part of the conspiracy.
I can't speak to that. The part of the conspiracy concerning his employment. I can't remember. I'd have to look at the transcripts.
Now, Detective Booth, you had a video recording of your interrogation of Mr. Ray.
All interviews are audio and video recorded, yes.
Including this one, correct?
Yes, as I said, all. This is included in all.
And you had an opportunity to preserve the video.
I did preserve the video. Or I'm sorry, I did preserve the interview.
You did preserve the video.
No, I preserved the interview.
You preserved the video and audio recording of the interview.
No, the audio video was not preserved.
Because you chose not to preserve that video.
I chose to preserve the transcript.
Which means you chose not to preserve the audio and video recording of the video.
Yes.
No further questions, Your Honor.
Thank you. Any redirect, Mr. Honey?
Just very briefly, Your Honor. Detective Booth, where was Timothy Ray when you arrived at the office at the police station?
I can't remember off the top of my head. I believe he was in the interrogation room.
Okay, and how do you document those interviews?
Well, like I said to opposing counsel, all interviews are documented with audio and video.
And do you have any other means of documenting your interviews other than audio video?
Yes, there's also options such as preserving a transcript for the record.
And how did you choose to document this interview with Timothy Ray?
I apologize. I requested a transcript of the interview.
And why did you choose a transcript and not a copy of the video?
Because his confession was so cut and dry that I did not see a need for the video.
And then what happens with that audio video recording?
Well, all audio video recordings are automatically erased from the system after 30 days.
Did you delete the audio, Detective?
No, it automatically erases. I don't have anything to do with that.
No further questions, Your Honor.
Thank you. All right, please call your next witness.
Your Honor, the state of West Carolina would like to call Dr. McLaGreca to the stand.
Thank you. Doctor, good morning. You've been sworn. Please keep your voice loud and clear.
Good morning.
Good morning. May it please the court.
Please.
Dr. LaGreca, would you mind introducing yourself to the jury?
I am Dr. Mac LaGreca.
And what is it that you do for a living, Dr. LaGreca?
I am a forensic psychiatrist.
And can you tell the jury what exactly a forensic psychiatrist does?
A forensic psychiatrist focuses on the relationship between psychiatry and the legal system.
Speaking of the legal system, what is your relationship to this particular case?
I have been retained by the state of West Carolina to provide an expert opinion regarding Timothy Ray's mental health on the date of October 17, 2018, the day that he killed his son, Nathan.
And doctor, have you ever testified as an expert in this field before?
I have. I have acted as an expert in 7 cases. 3 of those were specifically related to schizophrenia.
And doctor, have you only testified on behalf of the state?
No, I have also testified on the behalf of defense.
Doctor, I'd like to take a step back here. What educational credentials do you possess?
I have many years of formal schooling. This includes a bachelor's degree of chemistry from the University of Delaware, a medical degree from the University of Pennsylvania, a general psychiatry residency at UCLA, and my forensic psychiatry fellowship at the University of Pennsylvania.
And doctor, do you operate your own psychiatry practice in the present?
Not anymore. I used to run my own private practice, LaGreca Psychiatry Associates, for 23 years.
And did you treat mentally ill patients during that time span?
Yes, I did.
Doctor, did you treat patients with schizophrenia during that time span?
Yes, I have.
Doctor, why do you no longer have your own practice?
I decided to sell my firm and accepted a position as the program director of a forensic psychiatry fellowship program.
Oh, congratulations. Where at?
At the West Carolina School of Medicine.
And do you still treat patients at the West Carolina School of Medicine?
I do. I treat patients once a week at the James Spear Hospital.
Doctor, have you ever been published in the field of forensic psychiatry?
No, I have not. Until recently, upon my entry into academics, my career has been entirely devoted to treating patients. I am, however, now working on a paper.
Well, you are licensed as a psychiatrist.
Yes, of course. I am licensed in 3 different states, including West Carolina.
And doctor, are you board certified?
I am board certified in forensic psychiatry by the American Board of Psychiatry and Neurology.
And do you have any current memberships to any other professional psychiatric organizations?
Yes, I do. I am a proud member of the American Psychiatric Association, the American Medical Association, and the American Academy of Psychiatry and the Law.
Did you ever occupy any leadership positions within any of those organizations?
Yes, I have. I was actually the past president of the American Psychiatric Association.
Doctor, what materials did you review in order to form an opinion on Timothy Ray's mental health?
The depositions and all of the evidence contained within the materials provided in the joint exhibit list.
And doctor, in formulating your opinion, did you reliably apply principles and practices that are commonly used in your particular field?
Of course, my opinions within this report are based on information I have acquired from my research of medical literature, personal experience in private practice, education, training, and teaching.
Your Honor, at this time, the state requests that Dr. Mac LaGreca be formally tendered as an expert witness in the field of forensic psychiatry.
Mr. Fay, your position, please.
Your Honor, the defense would like to know as to whether the doctor applied those reliable principles and methods to the facts of this case.
That is not a qualifications question. That will come up later. In terms of qualifications, do you wish to either ask questions or take a position on whether the doctor is qualified?
The defense has no voir dire at the moment, Your Honor.
Okay, and hearing no objection, your tender is accepted. The doctor may testify as an expert before this jury.
Thank you, Your Honor. Dr. LaGreca, have you come to an opinion regarding the mental health of Timothy Ray on the day that he killed his son?
I have.
Doctor, what is that opinion?
It is in my opinion to a reasonable degree of medical certainty that on October 17, 2018, Mr. Ray did not suffer from any severe mental disorder, including schizophrenia.
Doctor, I'd like to talk a little bit about how you formulated that opinion. Is there a reliable authority that experts in your field use to diagnose mental illness?
Yes, the DSM-5.
And for the jury, can you explain what is the DSM-5?
It's a diagnostic and statistical manual. It's the manual used by forensic psychiatrists to diagnose mental illnesses like schizophrenia. It's also used as a guide for mental health professionals on whether a patient is malingering.
Malingering. Doctor, what is malingering?
Malingering is when a person pretends to have a disease characterized by intentional production of false or exaggerated physical or psychological symptoms.
And Doctor, what information did you rely upon in evaluating whether Mr. Ray was suffering from a severe mental illness on the day that he murdered his son, Nathan?
I relied upon the statements and medical history given by Mr. Ray's former physicians, Dr. Riley and Dr. DiGiuseppe. I also relied upon the observations made by Mr. Ray's former wife, his former employer, his father, and detectives who arrested Mr. Ray. And finally, I evaluated statements given by Mr. Ray himself.
Now, Doctor, did you interview all of these individuals yourself?
No, I used the interviews conducted by the detectives, Mr. Ray's former physician, and the district attorney and Dr. Riley.
Is this the type of data that other experts in your field would reasonably rely on in forming a medical opinion?
Yes, it is.
And can an accurate diagnosis be made without considering the content of the statements that you examined?
No, to accurately evaluate whether a person is mentally ill or malingering, it is important to consider the objective evidence and to compare it against the symptoms that the patient says they have.
Doctor, what did you find relevant about Timothy Ray's medical history?
I found it relevant that the first time Mr. Ray ever reported symptoms of delusions, hallucinations, or serious mental illness was a year after he murdered his son.
And was Mr. Ray ever previously exposed to medical professionals prior to that time who would have recognized and diagnosed him with mental illness?
Yes, several times. The first time was back in 2010, just after completing basic military training.
When did Timothy Ray join the military?
In 2009.
Did he stay in the military long?
No, shortly after he completed his basic training, he was discharged for other designated physical and mental conditions at the discretion of his commanding officer.
Why did the commanding officer recognize Timothy as mentally unfit?
According to the commanding officer, over the course of a month, Timothy experienced difficulty sleeping, hallucinating, depression, and suicidal ideation.
Now, did Timothy admit that he was experiencing these symptoms?
Timothy only admitted he was experiencing depression and anxiety. However, he denied experiencing hallucinations and suicidal ideation.
Well, after the concerns were expressed by the commanding officer, did Timothy get professionally evaluated?
Yes, he was.
By whom?
By Dr. Major Riley.
And did Dr. Riley diagnose Timothy Ray at that time?
Yes, he did in 2010.
Did he diagnose Timothy Ray with schizophrenia?
No, he did not.
What was Dr. Riley's diagnosis?
General anxiety disorder.
And what happened immediately after that diagnosis was made?
After 3 days, Dr. Riley determined that Timothy was not a danger to himself or others, so he was discharged from the inpatient service care.
Is that all that Dr. Riley wanted to happen?
No, Dr. Riley also suggested that Timothy should meet with a therapist and follow up with his primary care physician.
Did Timothy meet with a primary care physician?
Yes, he did. He met with his primary care physician, Dr. DiGiuseppe.
Wait, so Mr. Ray met with another medical professional that could have previously recognized and diagnosed him with severe mental illness?
Yes, that is correct.
And how many follow-ups did he have with Dr. DiGiuseppe?
He followed up with Dr. DiGiuseppe 3 times from 2011 to 2017.
So did Dr. DiGiuseppe diagnose Timothy Ray with schizophrenia?
No, she did not.
Did she diagnose Timothy with any form of mental illness, mild or otherwise?
No, she did not.
Well, did she prescribe him any medications for the depression or anxiety over that 7-year span?
No, she did not.
So was there any part of the interaction between Dr. DiGiuseppe and Timothy Ray that you found relevant to the case?
Yes, there was.
Can you elaborate for the jury?
You see, Timothy told Dr. Giuseppe that Jess had planned to leave him, and the defendant told Dr. Giuseppe that I won't let them leave me, I just won't.
Doctor, I'd like to talk to you a little bit about Dr. Major Riley's new view. Has the defendant, Timothy Ray, been diagnosed with schizophrenia in the present?
Yes.
By whom?
By Dr. Shane J. Riley.
Now, Dr. LaGreca, is this the same Shane Riley that examined Timothy Ray in the military in 2010?
Yes, Dr. Riley has been retained by the defense as their expert witness. He changed his mind about his original diagnosis.
Before or after being retained by the defense?
Section speculation to the last comment.
Your Honor, this is not speculative. This actually goes to the bias of the witness. Furthermore, we know for a fact that the report was issued after he was retained by the defense.
Overruled.
I'll ask again, Doctor, did Dr. Riley change his opinion before or after being retained by the defense to testify?
After being retained by the defense to testify.
And in his report, did Dr. Riley address the possibility of malingering?
Yes, he did.
And what did he find in his report?
Dr. Riley admitted that he could not say with certainty that Timothy Ray was not malingering and that that possibility exists.
So let's pin down this malingering business a little more precisely. What information do you require in order to tell if a person is pretending to have a mental illness or malingering, as you described?
One way to evaluate this is if there's a marked difference between what the patient claims and the objective findings.
Is this particular factor relevant to the case?
Yes, it is. Timothy Ray had never been diagnosed or treated for schizophrenia prior to murdering his son. Furthermore, there are several marked discrepancies between the patient's experiences and objective findings.
Doctor, can you provide the jury an example of such a discrepancy?
Sure, Timothy Ray never admitted to experiencing hallucinations. He also told different stories about the night of the murder to the detective and Dr. Riley, that the laptop was possibly smashed in one instance, and in the other, Nathan spilled apple juice on his laptop.
Well, why would someone pretend to be afflicted with a mental illness, doctor?
Examples of such incentives include avoiding military duty, avoiding work, or even evading criminal prosecution.
And do you believe in your expert opinion that those motivations are present in the case of Timothy Ray?
Yes, I believe he is
Objection.
malingering.
Relevance. We're here to determine his opinions, not his beliefs.
I withdraw the question, Your Honor.
Okay.
Dr. LaGreca, is Timothy Ray schizophrenic?
No, he is not.
Dr. LaGreca, is Timothy Ray malingering?
Yes, he is.
No further questions. The state passes the witness, Your Honor.
Thank you. Counsel, cross-examine.
Dr. Greca, you believe that Timothy Ray is not schizophrenic, correct?
That is absolutely correct.
Well, let's talk about that then. You'd agree with me that there are certain risk factors for developing schizophrenia, correct?
Of course, there are plenty of risk factors.
Right, and one of those risk factors is childhood trauma, correct?
Correct. It does increase odds per se.
It does, and you'd agree that Timothy had childhood trauma.
I would agree so based on the readings I've had.
And you'd agree with me that another risk factor for schizophrenia is untreated anxiety, correct?
In some cases, depending on the severity of the anxiety.
Well, in this case, as far back as 2010, Tim was diagnosed with general anxiety, correct?
That is true with 1 in every 5 Americans.
I didn't ask about 1 in every 5 Americans. I asked if he was diagnosed with general anxiety back in 2010.
And I said he was, as long with 1 in 5 Americans.
And you'd agree with me that Timothy's anxiety had gone untreated, correct?
Depending, he did not seek further treatment. He was given from Dr. Major Riley to see a therapist to further evaluate his anxiety, but he decided not to.
Right, he decided not to. And you're also aware that Timothy was prescribed Paxil by Dr. Riley, correct?
At that time.
Yes, but you don't know if he took that Paxil, right?
Which is correct, which is somewhat common in
Your Honor,
malingering.
this is speculative. The expert witness can't possibly testify to whether Timothy Ray ingested his medication in the years between 2010 and 2019.
The objection is overruled. It was asked, do you know? Next question, Mr. Fay.
In addition to risk factors for developing schizophrenia, there are signs and symptoms that someone actually has schizophrenia, correct?
Well, of course, that's how you diagnose it.
Yes, and you rely on the DSM-5 to come to this diagnosis, right?
Yes, as with every other psychiatrist.
And the DSM-5 needs 3 indicators for schizophrenia, correct?
Correct.
And in the first indicator, you only need 2 sign or symptoms to be present for a time span of 1 month, correct?
That is correct.
One of those signs and symptoms is delusions, right?
That is correct.
Another one of those symptoms is hallucinations, correct?
That is correct.
And you would agree with me that if someone had both delusions and hallucinations alongside the remaining criteria, they could be diagnosed with schizophrenia in the DSM-5, correct?
Only if they have those symptoms, correct?
Because they would satisfy the 2 requirements under that first element, correct?
as long as they truly had those symptoms and were not malingering.
So if Tim did have these delusions and hallucinations and met all the other remaining criteria, he would have schizophrenia pursuant to the DSM-5, correct?
That is not taking into account if he's faking it or has other issues.
I didn't ask if he was faking it. I asked simply if he satisfied all those elements, he would have schizophrenia pursuant to the DSM-5, correct?
If he truly did satisfy those elements, correct.
All right, well, let's talk about some of Tim's delusions here. You'd agree with me that Tim had delusions, correct?
I do not necessarily agree that he truly did have those delusions.
Well, Tim asked Officer Wentz if she was a part of the CIA, right?
At that time,
But
after
Officer Wentz is
murdering his
not
friend.
in. But Officer Wentz is not in the CIA, correct?
That is correct.
Tim asked Officer.
This is hearsay. The statements made by Timothy Ray are hearsay and they're inadmissible in this cross-examination.
Mr. Fay.
Your Honor, pursuant to federal rules of evidence 703, experts may rely on hearsay evidence to come to their opinions. Dr. LaGreca has been tendered as an expert.
I think there's a separate argument, gentlemen. Saying you are in the CIA is not for the truth of the matter, but it is offered to show mental output. The objection is overruled.
Tim also asked Officer Booth if she was a part of the CIA, correct?
That is correct.
But Officer Booth's not in the CIA, right?
Of course not.
And Tim, in fact, thought the federal government was out to get him, right?
Yes, only after the night of the murder.
But there is no evidence in the materials they reviewed that the federal government was out to get him, correct?
Of course.
Tim thought this because he claimed the government thought he was a terrorist, correct?
That is somewhat correct.
But Tim also believed that his wife and child were conspiring against him. Isn't that true?
That is true.
To cut him up into little pieces, correct?
That is what he said.
But there's no evidence that Jessica conspired to cut Tim into little pieces, right?
That is correct.
You'd agree with me that Tim had hallucinations, correct?
I do not.
Well, let's talk about that. As a child, Tim reported hearing voices that weren't there, right?
Only after his second time with Dr. Riley in 2018.
I didn't ask when he reported these. I asked if he did. And Tim reported having these hallucinations when he was a little child, correct?
Yes, in 2018.
Between 2010 and 2018, Tim heard voices that weren't there, right?
Never. He denied it until 2018.
I did not ask when he denied it. I asked whether he reported it. And he reported these, correct?
He reported it in 2018.
Between 2010 and 2018, Tim reported seeing shapes on the wall, correct?
That I am unsure of.
Well, that would be something to be important to be sure of, right?
For seeing shapes on the wall could simply be issues with visual acuity.
Right, because if you knew that there were shapes on the wall, then it would not be a hallucination, correct?
I do not understand that question.
If something was actually there, it wouldn't be a hallucination, right, doctor?
Objection, Your Honor. How is this line of questioning relevant?
Overruled.
I'm unsure what you're asking with if it's actually there. If not, your brain can see things with eyes that may not necessarily be there.
Okay, and on October 18, 2019, Officer Booth was told by Tim that they told him to do it, correct?
That is correct.
And that he needed to be punished, correct?
That is correct.
But Officer Booth said that there was no one else in the house on October 17th, 2018, right?
That is correct.
Okay, let's talk about why you think Tim is faking his symptoms. According to
Absolutely.
the DSM-5, malingering is evidenced by a fact of a lack of cooperation during a diagnostic evaluation, correct?
That is correct.
And in your opinion, it is based on the belief that Tim was not cooperative with Dr. Riley during his evaluation, right?
Absolutely. I certainly believe that.
But you weren't there during that evaluation, right?
The defense barred me from being able to talk with Mr. Wright himself.
I didn't ask about what the defense did. You were not there during that evaluation, correct?
Yes, and I was providing explanation why I could not.
So you weren't able to hear his voice, right?
No, I wasn't able to because
And you
of
say
what
this
I previously
despite-
stated.
And you say this despite the fact that Tim was cooperative during that evaluation, according to Dr. Riley, right?
That he was not cooperative, yes.
Riley said that he was cooperative, correct?
Based on the transcript and the reading, it did not seem like he was.
You also say that Tim faked his symptoms with Officer Booth and Officer Wentz, correct?
I do believe that.
And just to be clear, you were not at the police checkpoint on October 17th, 2018, right?
It'd be pretty hard for me to be there.
And just to be clear, you were not at the interrogation room on October 17th, 2018, right?
I mean, I'm not a police officer, so how would I be in the interrogation room?
In fact, you did not see Timothy Ray at all prior to this court date, correct?
Well, before this court day, I never would have known him, and then I was barred from the defense to be able to interview him personally.
All right, well, you'd agree with me that you cannot say with 100% certainty that Timothy is malingering, right?
You can never say anything with 100% certainty that someone is malingering or has schizophrenia.
That is true, and you'd agree with me that a vast majority of the time that malingering does not happen, correct?
I would disagree with that.
Well, you mentioned in your reports, you were working on research that indicated that 19% of the time malingering does happen.
That is
right?
roughly 1 in 5. That is, in my opinion, rather common.
Okay, so then 4 in 5 times malingering does not happen, right?
That is correct, but that must be taken into account with other factors into the case, such as discrepancies.
No further questions, Your Honor.
Thank you very much. Mr. Van Zandt, any redirect?
Yes, Your Honor, very briefly.
Go ahead.
Dr. LaGreca, were either of Timothy's parents ever diagnosed with schizophrenia?
No, they were not.
When did Timothy Ray admit that he was experiencing hallucinations?
In 2018, a year after the death of his son.
Last question. Is Timothy Ray a member of the 19% of patients that are malingering?
Yes, he is.
Objection.
Basis, Mr. Fay.
Relevance is to statistical analysis of whether this defendant falls into a category pertaining to statistics.
Your Honor, I do believe that was the entire point of the latter portion of co-counsel's cross-examination.
He is asking about the numbers that you elicited, Mr. Fay, respectfully overruled. You may ask that as your last question, Mr. Van Zandt.
I'll ask again, Dr. LaGreca, is Timothy Ray a member of the 19% of individuals that are malingering to evade criminal prosecution?
Yes, he was, or is he?
No further questions. Thank you, Doctor.
Thank you. Does the state have any further evidence?
No, Your Honor, at this time, the state rests its case.
Okay. Does the defense have any matters we need to take up before we have a recess?
Yes, Your Honor. At this time, the defense moves pursuant to federal rules of criminal procedure. 29 moves for a motion for acquittal.
Let me do this. Let me take us at sidebar. May I have a representative of the prosecution for this argument, please?
Yes, Your Honor, here I am.
Thank you, Mr. Van Zandt. Now at sidebar, Mr. Fay, what is the ground for your objection under Rule 29?
Your Honor, the prosecution has failed to prove beyond a reason, in viewing the evidence in light most reasonable or favorable to the prosecution, they have failed to prove beyond a reasonable doubt that Timothy Ray had the requisite mens rea and intent requirement, as well as that this crime was committed with malice aforethought. At no point during the prosecution's case in chief did they elicit or bring up any evidence addressing whether Timothy Ray had the requisite intent as well as premeditation, which are elements that must be satisfied by the prosecution that they have not met beyond a reasonable doubt.
Let me hear very briefly from Mr. Van Zandt. Counsel.
Your Honor, given the confessions that have been admitted into evidence by Timothy Ray, the confessions to the gruesome murder, we have proven beyond a reasonable doubt that he did, in fact, murder his son. We've also proven beyond a reasonable doubt that he had malice aforethought because he went into his room and systemically made the strategic decision to kill his son. That was a decision that was made. And if you look at the standards for malice aforethought, we don't need to prove that at any point Timothy Ray had any ill will or hatred towards the victim. It doesn't matter if Timothy Ray says that he loves his son, because it has been proven beyond a reasonable doubt that Timothy Ray has murdered his son.
Gentlemen, I'm not sure the reasonable doubt standard applies at Rule 29, but regardless, there is certainly sufficient evidence from which a jury could conclude, based on the deliberate choice of the belt and the amount of time it takes to strangle, that this, I'm not saying you can't argue that beyond a reasonable doubt, Mr. Fay, certainly, but at this stage, that is denied. Let me ask the following. Court is in recess, but before we do that, may I ask each timekeeper to unmute and tell us your respective time checks and see if they are in accordance?
Yes, Your Honor. As a defense timekeeper, I have the prosecution used up 31 minutes and 49 seconds, and accordingly, they have 23 minutes and 11 seconds left.
All right, do me a favor, stop there. Would the prosecution timekeeper jump in? Are you in essential agreement with that time?
Yes, I am.
Okay, so 23, I'm going to round it up, 24 minutes left for the prosecution. Thank you. Prosecution, while you're unmuted, what do you believe the defense has used?
I have them tallied at 19 minutes and 38 seconds.
Okay. Defense, what do you think you used?
I have them at 19:30, Your Honor, so very close.
We are certainly close enough. So with a total of 55, I'm running that to 36. So it's 24 minutes remaining for the prosecution, 36 remaining for the defense. That seems to be correct. Here's what we will do. We are going to take a 6-minute break. Do whatever you need to do, glass of water or whatever. I'm going to time it. We will resume precisely in 6 minutes. Thank you, everyone. Gentlemen, welcome back. Let me just check, are all four attorneys back? I see three of you. I am missing Mr. Van Zant, so we'll give him a moment.
I am here, Your Honor.
You are.
I just
Great.
don't have my camera ready to go yet.
Super. All right. Counsel, court is reconvened. This is the defense case. Defense, will you call your first witness, please?
The defense calls Officer Wentz to the stand.
Thank you. Officer, good afternoon now. Officer, you have been sworn. Please keep your voice loud and clear. Counsel, you may proceed.
Please introduce yourself to the jury by stating your full name, spelling the last.
My name is Officer Peyton Wentz. My last name is spelled W-E-N-T-Z.
Now, where are you an officer?
Here in Skelton, I've been a police officer here for the last 2 years.
Can you walk us through some of your training?
Sure. I got my bachelor's degree in criminal justice in college, and then after college, I went on to the Skelton Police Academy, where I completed all the basic training to become a police officer.
I would like to turn your attention to the events of October 19th, 2018. Do you remember that day?
Yes, I could never forget the day I met Timothy Ray.
Well, what happened that day?
Well, it was a typical sobriety checkpoint in downtown Skelton, my normal assignment. Mr. Ray's car approached the checkpoint, so I walked over and signaled him to roll down his window. It was nothing but downhill from there.
It was downhill. What do you mean by that?
I asked to see his license and registration, and the guy was not happy. He got all antsy and asked me why I needed them. I told him it was just a routine traffic stop, and we needed to get them from every driver that came through the checkpoint.
Now, were you able to get his license and registration?
At first, no. He was just all squirrely and defiant. He said he forgot it, his wallet and registration, but when I pointed out that his wallet was right next to him, he eventually gave it to me. I brought the license and registration to my partner, and then I went back to Mr. Ray's car.
Did you notice anything in Mr. Ray's car?
I did. I took a look into his backseat of his car, and I noticed a dirty shovel, 2 jugs of bleach, and large trash bags.
After noticing the dirty shovel, the bleach, and the trash bags, what happened next?
The guy started asking me out of nowhere, like, are you with the CIA? Like I hadn't just explained to him a minute earlier, this was just a routine traffic stop.
Officer Wentz, are you in the CIA?
No, I'm not. And I told Mr. Ray several times I'm just a police officer and that I'm not in the CIA, but he didn't seem completely convinced.
Can you explain what you mean by he wasn't convinced?
He just kept talking and talking. He was saying things like he knew the CIA had been watching him because they thought he was a terrorist. He even frantically said he could hear sirens of the CIA coming to get him.
Did you hear any sirens that day?
No, there were absolutely no sirens. The only people that were there were Mr. Ray, myself, and my partner. I told him there were no sirens.
Okay, after the sirens dilemma, what happened next?
Well, at this point, I asked him to please step out of his car, but he kept asking to see my CIA credentials. So again, I showed him my police badge and I reminded him I was just a police officer doing a routine traffic stop. After I told him all that, he finally got out of the car, but even the way he got out of the car was strange.
How was it strange?
Well, up until that point, he'd been so frantic and with all that paranoid stuff, but he slowly opened up the door and got out, and then he changed. It was like he was a zombie. He was moving super slowly, and he had a completely blank stare on his face. He wouldn't make eye contact with me either.
Did Tim say anything to you as he got out of the car, as you put it, like a zombie?
Well, not exactly to me, but yes, he was talking in a monotone voice, and even though he wasn't talking directly to me, it was almost like he was talking to himself or no one at all. He was saying, I'm a good father. I didn't mean it.
Did you ask Tim what he meant by that?
I did. I asked him what he meant, and he just looked up at me like he hadn't noticed I was standing there and said, I was just trying to get my son in shape and get him to admit what he broke. My son just needs to do jumping jacks. And that's when Tim himself started doing a jumping jack.
After Tim started doing jumping jacks, what did you do?
I told him to stand still, but he was unresponsive. When he started doing another jumping jack, that's when I pulled out my gun and yelled at him to stop moving. He did stop doing the jumping jacks, but then he started to move his head, back and forth uncontrollably and was holding his hands over his ears. I was finally able to get his arms down and handcuff him, though.
After cuffing Mr. Ray, what happened?
He started speaking again, not exactly to me, but he was just rambling to himself in like a quiet and frenzied voice. He was saying, "He's gone. I can't believe he's gone. I'm a good father." And then my partner called out to me about Tim's license and registration.
What did your partner find out about that?
He found out that Tim's plates had actually been flagged on a missing persons report that was filed just the day before about a missing little boy, who actually turned out to be his son, Nathan Ray.
And after finding out about the missing persons report, what did you do?
That's when I called in and reported that I detained the suspect in the missing persons case. And then Detective Booth came to the scene and he directed me to drive Tim to the police station.
No further questions.
Thank you. Mr. Van Zant, do you wish to cross-examine Officer Wentz?
Yes, Your Honor. Good afternoon, officer. Thank you for being here today. You haven't been on the force long, have you?
For a few years.
Oh, just 2 years. Am I correct?
Correct.
And this is your first time testifying, isn't it?
It is.
You aren't a detective, are you?
I am not.
You're a traffic officer, am I correct?
That's correct.
So just for the record, you've never actually been part of a homicide investigation.
I have not.
I'd like to talk to you about the night of the stop. You were working the night of October 19th, weren't you?
I was.
And you were working at a DUI checkpoint.
That's correct. That's my normal assignment.
But you were working a double shift that evening, correct?
I was.
And that was your first double shift as a police officer.
Objection, relevance.
Overruled.
I'll ask again. That was your first double shift as a police officer, am I correct?
Correct.
And you were exhausted during the shift.
I was tired, but I wouldn't say that it impaired the way I experienced the events that day any differently.
But you would say you were exhausted.
I would say I was tired. I guess.
Well, officer, you made a statement to the detective at the precinct after detaining Timothy Ray, am I correct?
Correct.
And you remember giving this statement?
I do.
Do you have the trial notebook in front of you, officer?
I do. One moment.
May I please turn your attention to page 46, lines 6 and 7, officer?
Yes.
Is that a fair and accurate copy of the statement that you made to the detective?
Yes.
I'm going to read lines 6 and 7 aloud, if that's okay, and you can tell me if I read these properly. Just a moment, my apologies. Ah, yes, here we are. Are you looking at Exhibit 5 right now, officer?
I am.
On lines 6 and 7, these were your words, am I correct? Sure, I was on a routine night shift assigned to the sobriety checkpoint. I was working a double, actually, so I was exhausted. Did I read that correctly?
Yes.
Let's get back to the checkpoint. You apprehended the defendant at the...
I'm sorry, Mr. Fay, were you saying something?
Objection, Your Honor, to improper impeachment.
Because
there was no indication as to whether this prior statement was made under oath or anything elicited by opposing counsel to lead the jury to that conclusion.
I don't think they implied it was under oath.
No, they did
Respectfully,
not.
under Rule 613, Mr. Fay, the objection is overruled.
Officer, I'd like to talk to you more about the apprehension of the defendant at the checkpoint, if I could. You apprehended the defendant at the DUI checkpoint you just mentioned, correct?
Yes.
And you spoke to him at the checkpoint.
I did.
And you didn't know the defendant before then,
I did not.
but he looked disheveled.
Yeah. I would say so.
And he stunk.
What do you mean by stunk?
There was body odor radiating from him.
Yeah,
And he was antsy.
he was antsy.
So you asked for his license.
I did.
A pretty standard protocol, correct?
Yes,
But Timothy Ray acted like he didn't have his license, am I right?
that's correct.
But he did have his license.
He did.
You could see it in the front seat of the car.
Yes.
So Timothy Ray was lying to you.
Objection, speculation.
Your Honor, this doesn't require any speculation. The witness testifies that she saw the license sitting in the front seat of the car.
I think you've made your point, Mr. Van Zandt, that Mr. Ray said something contradicted by the physical evidence. Objection sustained. Move along.
Yes, sir. Timothy Ray ended up giving you his license.
He did.
And shortly after, he also reluctantly handed you his registration.
He did.
So you wanted to walk that information back to the cruiser so you could run it through the system. Am I correct?
Yes.
And as you passed by the defendant's rear window, you shined your flashlight into his back seat.
That's correct.
And you saw some items in the car, didn't you?
Yes.
You saw a shovel,
Yes.
trash bags,
Yes.
bleach,
That too.
and you started to get suspicious at this time.
Yeah, I'd say I was suspicious. Those aren't normal items that I see in the backseat of people's cars coming through the checkpoint.
Okay, so after you looked in the window, you walked back to the car where your partner Ray was located.
Correct.
And after handing off the information, you walked back to where Timothy was sitting in his car.
Yes.
And Timothy started asking some strange questions at this point, right?
Yes.
He started asking you if you were in the CIA.
He did ask me that.
It was talking about the CIA sirens that he could hear.
Yes.
And these questions, they seemed crazy.
I guess at the moment, yeah, they seemed crazy. Could you explain what you mean by that?
No, that answer will suffice. We're gonna have to move on. But I started asking you these crazy questions after you shined your flashlight into his back seat, right?
Objection, vague. The witness just testified saying she doesn't know what crazy means.
Just rephrase that, the most slightest to these questions.
Officer Wentz, the defendant started asking you these strange questions after you shined your flashlight into his back seat, correct?
That's correct.
After you walked his information back to your partner.
Correct.
You thought that Timothy Ray needed medical attention.
I don't remember.
Okay, that's no problem. We'll talk about the academy then. Do you remember the academy well?
I do.
Well, you graduated fairly recently, just a couple of years ago, correct?
That's correct.
And you received training specifically related to mental illness at the academy.
Yes, I did.
That's called crisis intervention training.
Correct.
And you took 40 hours total.
Objection, relevance.
I don't know where this is going yet, Mr. Fay, but I will wait and see. Renew your objection after we get through the background.
Your Honor, the resolution is coming very soon, I assure you. Officer Wentz, you took 40 hours of crisis intervention training total, didn't you?
Yes.
That's less than 2 days total, correct?
Well, I would say it's about a week worth of training.
Well, 48 hours is 2 days, right?
Mr. Van Zandt, I think we all know what 40 hours are, and sometimes people sleep. So let's not argue about days. Next question.
Officer Wentz, you majored in criminal justice, didn't you?
I did.
You don't have any degrees in psychiatry.
No.
Objection,
So
relevant.
you,
What is, let's go to sidebar. Mr. Van Zandt, your colleague has objected on the grounds of relevance. Where are we going, kind sir?
I have one final question for Officer Wentz. It's whether she's qualified to diagnose the defendant with mental illness. She's not on the
I
grounds.
don't think she has been proffered as that.
No, of course not. I was just going to make sure to clarify for the purposes of the jury that.
I don't think the objection on that is sustained. She is a police officer, and you may so argue in your closing. Objection sustained.
Okay, thank you, Your Honor. No further questions at this time.
Very good. One moment. Any redirect, Mr. Fay?
Briefly, Your Honor.
Go ahead.
You mentioned on cross, Officer Wentz, that you work at a DUI sobriety checkpoint, and that's your usual placement.
That's correct.
Have you ever exhibited any people similar to what Mr. Ray was on that night at that checkpoint?
No.
No further questions, Your Honor.
Fine. Thank you, officer. You are excused. Thank you for your testimony. Does the defense have any additional evidence or witnesses?
The defense now calls its second witness, Dr. Shane Riley.
Thank you, Mr. Usha and Mr. Honey. Okay, Dr. Riley, welcome. You've been sworn. Please keep your voice loud and clear. Counsel, you may proceed.
Can you please introduce yourself to the court by stating your name and spelling your last name?
Dr. Shane J. Riley, Reilly.
And you mentioned doctor. What kind of doctor are you?
I'm a military forensic psychiatrist.
And how did you become a military forensic psychiatrist?
My education includes receiving my bachelor's degree in biology at the University of Notre Dame. From there, I went to the Uniformed Services University to complete my medical degree. From there, I completed my residency and fellowship at Walter Reed National Military Medical Center, completing my residency in psychiatry and my fellowship in forensic psychiatry.
And can you walk us through what your employment history is?
Yes. In 2003, I was able to complete a 7-year service requirement as a captain in the United States Army. I was the primary psychiatric consultant to the division's commander. I oversaw 20,000 soldiers. Afterwards, I returned to Walter Reed Medical Center, where I accepted a position managing the hospital psychiatric inpatient unit. In 2015, I continued to form my own private practice in forensic psychiatry. I realized many veterans with severe psychiatric disorders were often entangled in the legal system, so I decided to offer my services as a forensic psychiatrist to those who needed it.
Thank you for your service, Dr. Riley. Have you ever published any articles relating to schizophrenia?
I have. Out of the 15 peer-reviewed articles I published, 2 directly were related to schizophrenia.
Now, I want to ask you, why are you here?
I was contacted by the attorneys for Mr. Timothy Ray. Mr. Timothy Ray was a former patient of mine at Walter Reed. I was asked to review his case and form an opinion regarding whether and to what extent Mr. Timothy Ray suffered from any mental illness disorder and how that would affect his ability to discern right from wrong.
Did you formulate your opinions on this case?
Yes, I did.
What materials did you review to come to your opinion on this case?
I reviewed my notes from my former treatment of Mr. Timothy Ray. I also reviewed the materials supplied by the counsel. And I also reviewed the materials from my clinical interview with Mr. Timothy Ray and his close family and friends.
Are your opinions based off of sufficient facts and data?
Yes.
Are your opinions based on reliable principles and methods?
Yes.
Are all of your opinions to a reasonable degree of medical and psychiatric certainty?
Yes, they are.
Your Honor, at this time, the defense moves to enter Dr. Riley as an expert in the field of forensic psychiatry.
Mr. Honey, either any questions and/or any argument on the issue of qualifications?
No, Your Honor, the prosecution feels that the witness is well qualified.
Well qualified. Thank you, kind sir. Mr. Usha, your witness is qualified. Dr. Riley, you're permitted to proceed as an expert witness. Mr. Usha, please resume.
Dr. Riley, what are your opinions of Mr. Ray's mental health leading up to October 17, 2018?
My opinion of Mr. Timothy Ray's mental health includes that he had undiagnosed schizophrenia that continually exacerbated and worsened in symptoms.
And what is your opinion of Mr. Ray's mental health on October 17, 2018?
My opinion of Mr. Ray's mental health on October 17, 2018 was that he was having a schizophrenic episode.
We heard from Dr. LaGreca about schizophrenia and the DSM-5. Do you agree with Dr. LaGreca's definition of schizophrenia?
Yes, while I agree with Dr. LaGreca's definition, I do not agree with his application.
Let's talk about that. What are some of the risk factors for schizophrenia?
Some of the risk factors for schizophrenia include genetics, childhood trauma, and related mental illnesses.
Let's discuss childhood trauma. What are childhood trauma experiences?
Childhood trauma experiences are behaviors that can have an immense impact on a child's mental health and development, particularly predisposing them to mental illness.
Did Tim have the childhood trauma?
Yes, he did. According to my interview with Timothy Ray's father, his mother would refuse to feed Timothy Ray, force him to take cold baths, and neglect him.
You also mentioned untreated anxiety and mental health conditions. Did Tim have that as well?
Yes. In 2010, when I last saw Mr. Timothy Ray, I diagnosed him with generalized anxiety disorder.
And what does general anxiety disorder have to do with schizophrenia?
Generalized anxiety disorder can exacerbate the symptoms of schizophrenia, especially if gone undiagnosed and untreated.
Did Tim ever receive proper treatment?
So for generalized anxiety disorder, I prescribed Paxil and SSRI and also cognitive behavioral therapy. There's no medical record of him pursuing either.
Did Tim ever see any doctors between your first diagnosis and 2018?
Yes. Mr. Timothy Ray saw 2 doctors since the last time I saw him. The first doctor, he saw a primary care physician by the name of Dr. DiGiuseppe from 2010 to 2017. The second, he saw a physician at the correctional facility.
Let's talk about Dr. DiGiuseppe. Walk us through some of the visits with Dr. DiGiuseppe and what you noted about Tim's mental health from those visits.
So the first visit happened after his discharge from the military. Mr. Ray noted he had trouble sleeping. He was a bit anxious, but the doctor didn't want to put him on any sleep medications or any medications to treat his anxiety because she was worried that he wouldn't come off of them. The second meeting with Mr. Ray made the appointment because his wife thought that he was having mood swings and he needed medication. During the visit, he cried hysterically for a long time, and he was concerned that his wife and child at the time would leave. At the time, Dr. DiGiuseppe didn't think he needed serious medications or significant treatment. By the third visit, Dr. DiGiuseppe noted that he was a total mess. It looked like he hadn't showered for weeks. He was very in an unkempt state and expressed delusional symptoms using profanities. And at that point, Dr. DiGiuseppe noted that he needed serious psychiatric help.
Did Tim ever receive psychiatric help?
No.
Now, what would a psychiatrist use? What would be the factors that a psychiatrist use to diagnose someone with schizophrenia?
Sure. So the factors that psychiatrists would use would be the ones listed in the DSM-5 under the diagnosis of schizophrenia. This includes delusions, hallucinations, impairment with one's interpersonal relationships or self-care, and many other features.
Did Tim have hallucinations?
Yes, he did.
Talk to us about that. What hallucinations did he have?
So as early as the age of 10, Tim noted that he would have hallucinations. He would hear voices, but was afraid to speak out about them. Later on, in 2015, he noted that he had paranoia. He was afraid that his wife was having an affair, screwing around, and he feared that his wife and son would cut him up with a knife and leave him. Later on, in 2017, he expressed visual hallucinations for a few weeks. He noted them to be triangles on the wall that would change shapes or colors. And in early 2018, he noted to hear creepy male voices that would tell him to hurt people.
And did Tim have any delusions before October 17th?
Yes. In 2015, he had the delusion in the form of paranoia of his wife having an affair and fearing that they would cut his wife and his son would cut him up and leave him.
Given the presence of delusions and hallucination, what does that mean for the first factor in schizophrenia?
That they are present and would agree with the schizophrenic diagnosis.
You mentioned impairment. Did Tim have any impairment in his interpersonal relationships?
Yes. In my interview with Jessica Ray, Mr. Timothy Ray's wife at the time, she noted quite a change in the quality of their relationship. She noted that he would always have mood swings. He couldn't stop crying. And over the years, he became more isolated. During the tail end of their marriage, he would lock himself in the bathroom for hours and would go weeks without showering. By 2017, she explicitly said he was a different person and would plead him to go to see a psychiatrist.
Let's discuss your second opinion. Did Mr. Ray have hallucinations on October 17, 2018?
Yes, he did. He had them in the form of auditory hallucinations, voices telling him that he needed to punish Nathan Ray and get back at what he and his Jessica Ray were plotting against him at the time.
And did he also have delusions on that day?
Yes. So he had the delusion that Nathan Ray had spilled the juice as a way to sabotage him, to go out, get out to him, and really leave him. And
Can someone who has schizophrenia fail to understand right from wrong?
when someone has schizophrenia, they lose touch with reality. When someone loses touch with reality, it's difficult for them to tell right from wrong.
No further questions, Your Honor.
Thank you. Mr. Honey, do you wish to cross-examine?
Yes, Your Honor. May it please the court. Dr. Riley, first, let me thank you for your military service, sir. I want to talk previously about your experience as an expert witness. You've been hired as an expert on 25 prior occasions?
Yes, prior to this occasion.
And 17 times you were hired for the defense.
Yes.
You're being paid to testify for the defense today.
Yes.
And you're being paid over $8,000 for your review of the materials in your testimony.
Yes.
Objection to relevance.
Your Honor, bias is always relevant.
Agreed, overruled.
Thank you, Your Honor. Only one time have you ever been hired by a prosecutor.
Yes.
And you've only ever testified once at trial.
Correct.
And that trial ended in a mistrial.
Objection, relevance.
Sustained. Move along.
Let's talk about the likelihood of faking when facing serious charges. Now, you diagnosed the defendant with general anxiety disorder.
Yes, in 2010.
In your interview with Timothy Ray, your second was in 2019,
Yes.
and that interview was a year after his arrest.
Yes.
Prior to Nathan's murder, Timothy Ray had never been diagnosed with schizophrenia by any physician.
Correct.
The more serious the crime, the higher the likelihood of faking symptoms.
19% of the time, yes.
And the more serious the punishment, the higher the likelihood of faking.
19% of the time, yes.
It's more likely that a person facing murder charges would fake symptoms than a person facing, say, assault charges.
Yes,
And Mr. Ray is charged with the murder of his son, Nathan Ray.
yes.
Let's talk about the discrepancies in the defendant's story. Any discrepancy in what a defendant says and the actual fact is an indicator of malingering, of faking?
It's also an indicator, it's an associated feature with the diagnosis of schizophrenia.
But you have even said small discrepancies support malingering to an even stronger degree.
Yes,
The defendant told you Nathan smashed his personal laptop.
yes,
Later, the defendant told you that Nathan spilled juice on his work laptop.
yes,
The defendant told the detective that he hit Nathan with a belt on his bottom.
yes,
The defendant later told you he only choked his son with a belt.
yes,
The defendant told the detective he was in Nathan's room when he strangled Nathan with the belt.
yes,
The defendant told you he strangled Nathan with the belt in the kitchen.
yes.
These would all be examples of discrepancies in Timothy Ray's story,
Or memory deficits.
but they're discrepancies though, correct?
Yes,
Let's talk about your early assessment. I'm sorry, move forward. Let's talk briefly about functional consequences in the DSM-5. Occupational dysfunction is a functional consequence of schizophrenia,
yes,
and most individuals diagnosed with schizophrenia are employed at lower levels than their parents.
yes, but not always.
Well, there's no known work history for the defendant's mother.
No.
The defendant's father is a steel mill worker.
Correct.
Objection relevance as to the parent's occupation and mental health.
I will give Mr. Honey one or two more questions as I think he's about to blink it.
Thank you, Your Honor. I'll repeat that question. The defendant's father is a steel mill worker,
Correct.
and Timothy Ray was a technician at Computerland prior to his arrest.
Correct.
And maintaining employment is hard for a person with schizophrenia.
Depends on the case.
The defendant worked at Computerland, though, from 2011 up to his arrest in 2018.
Yes,
And prior to 2018, the defendant was considered a fantastic employee.
yes, with a few occasions.
The defendant had never been formally disciplined over 8 years of his work at Computerland.
No.
Completing education is difficult for a person with schizophrenia,
Sometimes.
but the defendant here had a bachelor's degree in computer science.
Yes,
The defendant graduated summa cum laude, I'm sorry.
yes,
And according to the DSM-5, completing education is difficult for a person with symptoms of schizophrenia.
yes, it can be difficult.
And in your in the direct, you said all evidence is pertinent,
Yes,
yet you did not include the defendant's college education in your facts relied upon.
yes, but schizophrenia
Your
affects.
Honor, no further questions. Thank you.
Mr. Honey, respectfully, he can finish answering the question. Go ahead.
Very well.
Doctor, you may finish your answer.
Patients present with symptoms and different predisposing factors in different ways.
Any
You would agree-
follow up to that, Mr. Honey? Please go ahead.
Yes, Your Honor. Doctor, you would agree that all evidence available would be relevant in making a decision,
Absolutely.
yet you did not include the college education in your facts relied upon.
No.
No further questions, Your Honor. Thank you.
Thank you, sir. All right, any redirect?
Briefly, Your Honor.
Please go ahead.
Can someone suffer from schizophrenia without a diagnosis?
Yes.
Can someone struggle with education and employment even with schizophrenia?
Yes.
And that they can eat, despite those difficulties, they can still obtain educational outcomes.
Yes. High functioning.
Is that what happened here?
It appears so.
No further questions.
Thank you. Let me just make a note, please. Okay, does the defense rest?
The defense now rests its case.
Okay. I am to say the following. Number one, I'm going to give each side, both sides together, literally 2 minutes. But let's get our time check first. Let me hear from the defense timekeeper, please.
Your Honor, may I have an additional 30 seconds or so to finish calculating?
Of course you may. How about the prosecution while we're waiting? Prosecutor, timekeeper?
Yes, I have the prosecution with 11 minutes and 30 seconds remaining.
11:30 for the prosecution remaining. How much do you have for the defense remaining, please?
I could just have 1 moment to calculate that.
Of course you may. I will tell you that my calculation is approximately 18 minutes left for the defense, but mine is unofficial. I'd like to hear from both timekeepers.
Your Honor, I have my calculations.
Go ahead.
For the prosecution, I have 11:34 remaining, and for the defense, I have 18:34.
All right. And let me get our other timekeeper for the defense.
Your Honor, that was a defense timekeeper. I'm
No,
sorry.
no, I understand. I was asking for the prosecution timekeepers count for the defense. I'm sorry.
Got it.
Do you confirm the 18:34 or thereabouts?
For how much time the defense has left?
Yes, sir, please.
Yes, I confirm that.
All right, so it's approximately 11 and a half minutes. Prosecution left, 18 and change, defense left. Here's what I'm going to do. I'm going to take 2 minutes so that each closer can set up completely. In the meantime, and I'm starting that now, I am asking, as per the directions we are given, that we're going to hear the closing arguments. We're asking that everyone switch back in the view frame to speaker view. I've done that now. And I will call upon counsel in 1 minute and 30 seconds, and we will begin closing arguments. I'm going to ask the timekeeper to please mute your microphone. Thank you very kindly. All right, that was 2 minutes. We are going to hear the closing arguments. I will ask that only the person arguing have their microphone and camera on. I will turn mine off and simply say, counsel proceed, and Mr. Van Zant, you may then begin. Counsel proceed.
If it may please the court and the jury and opposing counsel. Timothy Ray is not insane. Timothy Ray is conscious, controlling, and cold-blooded. He consciously walked into his bedroom, grabbed a leather belt, and decided to make that belt a murder weapon. He was losing control of his spiraling family dynamic, and he regained that control through violence. He was cold-blooded when he decided to engage in betrayal of the highest order, destroying everything that he was supposed to protect. Now, if you've been listening closely to the case presented by the defense, you might believe that the real victim in this situation is Timothy Ray, not Nathan, the innocent child that was violently murdered by his own father, and not Jess, the grieving mother that lost her world. The defense wants you to believe that Timothy Ray's struggling is paramount because of his rough childhood. But compared to Nathan, Timothy doesn't know what a rough childhood looks like. The defendant is simply trying to manipulate the legal system by pretending to be insane. Timothy Ray is an opportunist, fully willing to exploit and trivialize the plight of those struggling with mental illness in order to escape the consequences of his actions. Now, the defense retained two witnesses to sell their case. The first witness was Officer Peyton Wentz. Now, Officer Wentz seems like a woman of character, but she's an inexperienced traffic officer. The important thing to remember here is that Timothy Ray, a suspect in a missing persons investigation, only started asking Officer Wentz these strange questions about the CIA and the sirens after he realized that he was going to be caught. Speaking of convenient changes, let's talk more about Dr. Riley's new opinion. You see, Dr. Riley did not diagnose the defendant with schizophrenia in his first evaluation in 2010. Now, after being paid handsomely by the defense, he has changed his mind. Today, Dr. Riley testified that Timothy Ray is a violent schizophrenic. Dr. Riley's new diagnosis is simply not credible. Remember, Dr. Riley is personally responsible for releasing the defendant back into society after he decided that the defendant wasn't a danger to himself or others. So if Dr. Riley really believes his own testimony, then he believes that he let a violent schizophrenic walk without treatment. Either Dr. Riley is lying or he isn't a decent psychiatrist. Unsurprisingly, the defense and Timothy Ray share the same strategy. Take advantage of the empathy that people feel for the mentally ill in order to keep a calculated murderer from being held accountable. That being said, let's discuss what you heard from the state's witnesses. First, you heard from Detective Blake Booth. Blake Booth is a seasoned police officer that truly understands the gravity of murder investigations. Detective Booth told you about Timothy Ray's confession to the gruesome murder. He told you about how Timothy Ray was completely cognizant the entire time while he was signing his Miranda waivers. He also told you about the Google searches that Timothy Ray had made. Countries that don't extradite for murder, how to get rid of a body, will bleach, destroy a body. Do these sound like questions someone would be asking if they didn't realize they had done wrong? Timothy Ray did understand the consequences of his evil actions. That's why he was researching how to avoid them. You also heard from Dr. Mac LaGreca, and the defense attempted to discredit this Ivy League educated former president of the American Psychiatric Association, but Dr. LaGreca has impeccable credentials. And based on the discrepancies between Timothy Ray's stories and the almost comical exaggeration of stereotypical schizophrenic symptoms during convenient times, Dr. LaGreca asserts that Timothy Ray meets the DSM designated criteria for malingering. In other words, Timothy Ray is faking it to get out of trouble. Now, as members of the jury, please remember, since our burden has been met, the burden of proof actually shifted to the defense because of the insanity plea. They must now prove by clear and convincing evidence that Timothy Ray was not able to appreciate the wrongful nature of murdering his son. First, the defense must prove that Timothy was suffering from severe mental illness or defect at the time of the offense. But they failed to prove that Timothy Ray is schizophrenic. Timothy Ray had never even admitted to experiencing auditory hallucinations until after this desperate insanity defense was being formed, a year after the arrest. And second, the defense must prove that the severe mental illness prohibited Timothy Ray from appreciating the wrongfulness of his acts, but the evidence shows to the contrary. The evidence shows that Timothy Ray fully appreciated the wrongful nature of his actions. The disturbing Google searches and the apologetic admissions of guilt prove this point. Now, an important clarification needs to be made here. Schizophrenia does not equal insanity. Schizophrenia is a medical term and insanity is a legal term. Even if the defendant is schizophrenic, which he isn't, that doesn't mean that he was insane at the time of the offense. The defense is asking you to make an implicit logical leap from schizophrenic to insane, but the problem is they can prove neither. So what's the job? Well, we're not here to seek help for Timothy Ray. Timothy Ray has taken innocent life, and in doing so, he commits the most heinous atrocity imaginable. Our job is to seek justice for Nathan and for Jess. As long as Timothy is allowed to manipulate the justice system, there can be no justice for the people that he's destroyed. So when you go back and you fill out that ballot, I want you to write that Timothy Ray is guilty. Timothy Ray is guilty of first-degree murder. He is not insane. Remember his words, I will never let them leave me. I just needed to make him understand. I buried him. That was his voice, and those were his words. Timothy Ray is conscious, controlling, and cold-blooded. His made-up demons cannot be tried and sentenced for the murder of his little boy. Timothy Ray does not have a problem. Timothy Ray is the problem. Thank you.
Thank you, counsel. Mr. Fay, the floor is yours, sir.
Dr. Riley is not on trial here. Tim Ray is insane because the only way to explain this insanity is with insanity itself. No sane person hears voices that are not there. No sane person believes the government has labeled him a terrorist. No sane person willingly ends the life of their one and only child. Only insanity causes people to do these things. And insanity itself is the only explanation for what happened in this case. Now, before I go any further, I want to make something very clear. What happened to Nathan is tragic. We know the defendant killed his son, but justice demands an explanation as to why Nathan died. Insanity is why Nathan died. Members of the jury, the prosecution has a burden to prove to you beyond a reasonable doubt that Timothy physically ended the life of Nathan Ray, and that he mentally intended to do so. And we do not believe that they have met their highest burden. However, even if you feel that they have, Timothy will still be innocent. And he is innocent because there is a law made for cases just like this one that Timothy Ray has proven by clear and convincing evidence that he is insane. So members of the jury, that leads us to the next question. What is the legal definition of insanity? Well, according to the law that Judge Epstein is going to read to you, Timothy is legally insane because first, Timothy Ray suffered from a severe mental disease or defect at the time of the acts constituting the offense. And second, that as a result of the severe mental disease or defect, Timothy Ray was unable to appreciate the nature and quality of his acts. Members of the jury, we have seen this today through clear and convincing evidence that Tim Ray is insane due to schizophrenia. And this schizophrenia prevented him from appreciating the natures of his actions on October 17th, 2018. We have proven the first element of insanity because it is clear and convincing that Tim suffered from the mental disease of schizophrenia. It is clear and convincing that the DSM-5, Dr. LaGreca, and Dr. Riley all agree that childhood trauma and genetics can cause schizophrenia. Tim was starved, abused, and neglected by his own mother. The person who was supposed to give him warmth and comfort gave him cold baths and no food. Tim's mother was institutionalized because of this. And the result This childhood trauma caused Tim to hallucinate at just 10 years old. This resulted in Tim increasing his chances of schizophrenia. It is clear and convincing that untreated anxiety and depression increased Tim's chances of developing schizophrenia. Tim had untreated anxiety and depression in the Army. Dr. Riley actually met 10 years ago and diagnosed him with general anxiety disorder. Why did he do this? Because Tim's commanding officer reported him having hallucinations, that Tim was depressed, and he had all this anxiety while both of them were serving our country. Now, Tim was told to take Paxil and to see a therapist, but he never did any of those. The prosecution claims that Dr. DiGiuseppe was able to diagnose him, but they failed to note that she was just a family doctor. Family doctors don't treat schizophrenia like the experts in the courtroom today. And both experts in the courtroom today agreed that if general anxiety disorder is left untreated, it can cause schizophrenia. And that is exactly what happened to Tim Ray. His mental illness went untreated and caused schizophrenia. It is clear and convincing that Tim's untreated anxiety and depression evolved into schizophrenia. And we know this because Tim's wife, Jessica, left him and said that he became a completely different person. From 2010 to 2017, Tim would lock himself in the bathroom for hours. Tim would break out into mood swings filled with tears. And at the same time, Tim's doctor, Dr. DiGiuseppe, saw the decline of his mental health firsthand. At these checkups, what started off as anxieties about starting a family plummeted into hallucinations and delusions about ending that family. Tim believed that Dr. DiGiuseppe was in on a conspiracy with his own wife and son. Tim believed that Dr. DiGiuseppe was listening to his phone calls and talking to Jessica behind his back. This checkup was so insane that Dr. DiGiuseppe herself believed that her own patient was a threat to himself, that he might commit suicide. This checkup was so insane that she had to refer him to a psychiatrist. This checkup was so insane that she knew it was more than just anxiety. It is clear and convincing that just because Tim is sick, he never took Paxil or saw a therapist, and his schizophrenia simply got worse. In the months leading up to Nathan's death, Tim heard male voices telling him what to do, to hurt people, to do bad things to people, to simply do things that he did not want to do. Tim no longer had anxiety, members of the jury. He believed these voices were very real. He believed these hallucinations were controlling, and he believed that he had to carry out every single one of their commands. And on October 17th, 2018, Tim's beliefs became a reality he did not even know he was a part of. We have proven the second element of insanity, members of the jury, because it is clear and convincing that Tim had no idea what he was doing on October 17th, 2018. It is clear and convincing that reality was gone for Tim on October 17th, 2018. And we know this because Tim's delusions distorted his reality to believe that that was the night that his family was finally going to get him, that Jessica Ray and her 6-year-old son was going to finally chop him up. And what started all this, members of the jury? Spilling juice on his laptop. Who told Tim about this conspiracy? Well, they did. The same they who told Tim to hurt people months before. The same they who told Nathan that he needed to be punished that night. The same they who told Tim to pull that belt. It is clear and convincing that at the time of the killing, Tim believed that the government thought he was a terrorist. Tim believed the police officers that he met before, were members of the CIA. Members of the jury, these are all clearly delusions. Members of the jury, these are all clearly hallucinations. And these hallucinations and delusions became Tim. These hallucinations and delusions killed Nathan. It is clear and convincing that because of all these hallucinations and delusions, Tim did not know right from wrong on October 17, 2018. that if Tim knew right from wrong, he would not have killed his son. If Tim knew right from wrong, he would not have punished his son because they told him to do it. If Tim knew right from wrong, he would have ignored all the voices in his head and got help. But members of the jury, Tim did not know right from wrong because they were very real to him. Now, members of the jury, the prosecution wants you to believe that a sane person would kill their son. The prosecution wants you to believe that Tim's symptoms are comical, a joke. So the easiest way to get around this is to say that Tim's faking. And they paid Dr. LaGreca to do just that. It is clear and convincing that Dr. LaGreca spent more time in his own head than examining Tim's head. Just remember, members of the jury, you and Dr. LaGreca actually met Tim for the first time today, but he's the one with all the opinions. Dr. LaGreca said that Tim was not cooperative during his evaluation with Dr. Riley, and he says this despite the fact Dr. Riley says he was cooperative. We heard Dr. LaGreca say that he cannot say with 100% certainty that Tim was malingering. Well, members of the jury, that is reasonable doubt. And he even clarified that, saying, in fact, the majority of the time malingering doesn't happen. But he had to wiggle every single time I asked him a question. And why did he wiggle? Because the prosecution thinks that Tim's symptoms are a joke. Because the prosecution paid Dr. LaGreca to come to this opinion, because the reality of mental health is too hard to bear. Then we heard all about the DSM-5, and Tim only needed 2 of these symptoms. Tim had delusions and hallucinations. We also heard that risk factors can increase schizophrenia. And Tim even had factors of childhood trauma and untreated anxiety. Heck, even his own mother had mental health issues. Tim had all of these requirements for schizophrenia, and now Dr. LaGreca wants you to believe that he faked his childhood trauma, that he faked his hallucinations, that he faked his untreated anxiety, that he faked his genetics. And he faked all of these things before he even had a child. Members of the jury, you heard me ask Dr. LaGreca very simply that, hypothetically speaking, if someone had all of the symptoms, that they would have schizophrenia. Well, how did he respond? He said, that is the case, but Tim's faking. Dr. LaGreca wants you to believe all of this because Tim's schizophrenia is the only way to explain what happened on October 17th, 2018. And his ignorance goes to the contrary. Dr. LaGreca's ignorance of the facts is the reason why people like Tim do not get treatment. Because, members of the jury, who would want to get treatment from a doctor who claims that their patient is faking their symptoms without talking to them first? Well, apparently for Dr. LaGreca, saying he's lying, he's faking, he's malingering is a proper analysis of schizophrenia, is a proper analysis of what the prosecution claims is a comical symptom, that these symptoms are a joke. Dr. LaGreca is pretty confident in saying that Tim did not see or hear things that day, even though Dr. LaGreca never heard or saw from Tim. It is pretty clear that both Dr. LaGreca and Tim saw things that were not there. Nothing about Tim's mental health is a joke. Members of the jury, Tim is a sick man, and we live with the consequences of his illness, and he will live with the consequences of his illness for the rest of his life. The system failed Tim when he needed them most, and now the system is trying to cover up their tracks by saying that he's faking, by saying that his symptoms are a joke, comical. Members of the jury, this is the last time you'll hear from me. And when I sit down, the prosecution gets one more shot at this. So remember, Tim sits here today, a man desperately looking for help for his schizophrenia. You, members of the jury, are the only people who can give Tim this help. The only way to help Tim, and the only verdict when applying the facts to the law is to find him not guilty only by reason of insanity.
Thank you, Mr. Fay. Mr. Van Zandt, do you have any rebuttal?
Yes, Your Honor, I do.
The floor is yours, sir.
To address some of the things that were posited in closing by opposing counsel, first off, Dr. Riley is not on trial, but to at least some degree, his work is. Dr. Riley is the only witness here that provided conflicting and differing diagnoses. He changed his mind after the defense paid him thousands of dollars. Remember, during cross-examination, Dr. Riley admitted that all information at his disposal would be relevant in determining a final medical diagnosis. He also admitted that he left out imperative information about the defendant's education. This is just a single example of the bad work done with the intent of generating a particular result. This is bad science. Along those same lines, genetics can cause schizophrenia, but that doesn't mean much considering neither one of Timothy Ray's parents were ever diagnosed with schizophrenia. Let's talk about Dr. LaGreca's take on this issue. Dr. LaGreca is impeccably qualified, the former president of the American Psychiatric Association. He knows what he's talking about. This man has an Ivy League education that's thoroughly extensive. Dr. LaGreca was barred from meeting with Timothy by opposing counsel. Of course he didn't get to meet with Timothy. The attorneys on the other side of the aisle prevented that from happening. Why? On cross-examination, by the way, he didn't wiggle. His analysis was thorough and consistent. He dominated. Along Timothy Ray's lines now. Timothy's suffering is being framed by the defense as paramount because of Timothy's rough childhood. I implore you once more, think about the childhood experience now by Nathan Ray and see how that stacks up. Don't confuse humanity with insanity. Just because the evil acts perpetrated by Timothy Ray are difficult to understand, that doesn't make him insane. Remember, all of the evidence presented has indicated that Timothy Ray is conscious, controlling, and cold-blooded. Opposing counsel said the prosecution wants you to believe that a sane man killed his son. Yes, we do. By this fabricated definition of insanity, every bad deed could just be dismissed as insane. We would never be able to hold individuals accountable. We would just say that all atrocities are insane and unexplainable. Timothy Ray's behavior is not insane. It's not even just immoral. Timothy Ray's behavior is evil. And we aren't here to seek treatment for Timothy Ray. We're here to seek justice for the two people that he destroyed, Nathan and Jess. The system did not fail Timothy. Timothy put himself here. He did this to himself. There's no overarching reason. There's no failure on our part. Timothy Ray murdered his son, and he should be held accountable for that. Timothy Ray does not have a problem. Timothy Ray is the problem. It's our opportunity now to hold him accountable and seek what little justice left that we can for the grieving mother that had to watch powerlessly as her baby was lowered beneath the earth. Thank you.
Thank you, counsel. I'm going to ask that we return to gallery view. I'm going to ask the 3 scoring judges to please submit their ballots. And I ask everyone to stay on until the judges have told me the ballots have been submitted. Then we will have very brief comments. Can one of you gentlemen remind me what time the next round starts? Am I correct? It's 4? Eastern time, is that correct? Thank you. All right, so let's sit tight for a minute. You guys can loosen up your ties or have a drink of water. And then Juror Howell, are you submitted? Okay, we'll sit tight for our other 2 jurors and then we'll take comments. Juror Domineski, is your ballot submitted? All right. And we're waiting for Juror Purcell. Juror Purcell, you are submitted. So I am going to mute myself because I have to notify the powers that be that everything is submitted. But I will ask for a brief comment from each of our jurors Let's go alphabetically. That'll work. So Ms. Domineski, you take it on.
Yes, thank you. I'll keep this as brief as possible. Well, I just wanted to say I was very impressed with both teams. This is such a feat, conducting a trial like this over Zoom, and I just thought it was really impressive that you guys were able to do it so effectively. Specifically for each team, I had that, the defense, I thought you did a really good job translating this process into the Zoom process. Obviously when you're in the courtroom, you're trying to command the room and make it very interactive with the witnesses and with the jurors. And I thought that was really well done from the defense. I saw some movement, some gestures that weren't too distracting, but still felt like we were in the same room, and I think it really captivated my attention and the attention of my fellow jurors. Moving over to the prosecution, I was really impressed with the line of questioning, especially with this particular competition being Battle of the Experts. I thought the line of questioning did a really good job of kind of walking through these more complicated topics and then zooming out and bringing it back to what is the main idea. You tied in the theme really well multiple times. And I think that's a really important thing when you're dealing with expert witnesses, is getting through the nitty gritty, but then bringing it back to the main idea so that the jury knows what they should be taking away from this testimony. I thought both teams did a fantastic job, and I was very impressed.
Thank you. Juror Howell.
Thank you. I also am very impressed. And so I'm not going to belabor that point, even though it might be warranted, because you guys all did a great job. I just wanted to talk actually about what happened before the trial even started. I'm a trial attorney, and I want you to know that whether or not it plays well at competitions, surprise is not golden. I think just as advocates for whatever side you're on, you need to remember that you're here, you want to have as many things resolved as possible and the least number of surprises going into a trial, because not only is it stressful for you, it's actually stressful for the triers of fact to see a lack of communication between counsel and people scrambling to figure out what's going on, and just general conflict. You don't want conflict with opposing counsel to overwhelm the message that you're trying to present. And so I always make your best efforts to contact opposing counsel and to share what you're gonna have to share. I mean, by the rules, you're supposed to share your exhibits ahead of time so that you can talk about these things. So motions eliminate, I motion the heck out of my cases beforehand. So it's really like, we all know what's coming in and what's not. And it's not, the trial doesn't become about us and our conflict. It becomes about what happened here or didn't, and letting the jury decide. And so I just want to just commend you to do that just resolve as many conflicts as possible, and don't let your personal conflicts overwhelm your presentation of your case.
Thank you so much. Juror Purcell.
Hello, everyone. My name's Steve Purcell. I thought you guys did a fantastic job. I'll echo the sentiments of jurors Howell and Domineski that this is incredibly difficult what you guys did, and you did a really good job of making sure your passion came across, because obviously this is much different than being in a courtroom and you can get complacent, things like that. You guys did a very, very good job. I wrote down notes for each person. I'll just briefly, I'll give maybe a piece of criticism for each person. Mr. Honey, very good job on your cross. I really like the way that you handled the end. There was an objection there. You argued it and you didn't end it on the objection. I like that you followed up and did it and kind of got your point across, made it clear. So good job there. And just like your demeanor in general. Mr. Van Zant, I will say you obviously know what you're doing. Very smart. Slow it down a little bit. You're very passionate. In the closing, I thought you were kind of running your sentences together. For me, a piece of advice would just be to take your time a little more. Mr. Yusha, I like that you were the only one standing. I don't know if you guys were given instructions or anything like that, but I appreciated that you were up and about. I thought that was, kind of made me a little more invested. Felt like you were in the courtroom. But with that being said, there were a lot of hand gestures, kind of got confusing at some points. I don't know, that's obviously a strategic decision on your part, just my opinion. And lastly, Mr. Fay, very good job on your cross. The witness was being unnecessarily difficult. You did a really good job handling that and making sure you got the answers you wanted. So briefly, obviously we could talk about this all day, but again, great job. Best of luck to all of you.
All right. So I'm going to thank Juror Howell, because my first comment was you guys in competition and in real world have to talk to opposing counsel. Here are just a couple of others. They're tiny things because I want to do the stuff that will hopefully improve the game. I don't need to sit here and praise you on what you did well. Please never say thank you to a judge for ruling. Bad form, and some judges get really angry. Number two, it felt to me at some point that some of you were reading. Could watch your eyes and they were clearly looking down. And been a lawyer for 42 years and change. I've tried a lot of cases and I use notes, but try not to read. If you're at a place where I had to read, I have to read, do what you can to make it seem a little more eye contact to us. Two final things. One is we're in the throes of the competition, but I think I heard some facts in the closing argument that we all know are in the file, because every one of us knows this file backwards and forwards, but I'm not sure they were testified to in this round. So whatever you're doing, keep a checklist for your closing of, did we ask this question? Did we ask this question? Did we ask this question? The very final one, and again, I hope these are constructive ideas. Listen to the phrases your opponents use and see if you can grab them into your arguments. But with that, let me say thank you for all the work in the weeks and weeks and weeks it took to get here. I think I speak for myself and all the jurors in saying thank you for what was clear professionalism. And please, we are done. I'm going to close this meeting and you guys get your break before you get to do this again. All right, everyone, we are closing courtroom 7. Thank you, everybody.